Good morning, Texans. Welcome for another exciting session discussing what? Of course, the Texas legislative changes that we have the privilege of interpreting and deciding how best to comply with and enforce under. You may know me, you may not. My name's Clint Brown. I'm with Roberts, Markell, Weinberg, Butler, Haley, and I'm one of our shareholders at the firm based in Austin, Texas, although I visit all the big Texas cities, usually a few times a month. I've got with me Miss Boyd, Sipra. I will let you introduce yourself, ma'am.
Good morning, everyone. Thank you for joining us. My name is Sipra Boyd, and I'm one of the shareholders out of the Houston office. Happy to have everyone join in and learn about all these fun new laws.
Thanks, Sipra. All right, let's dig right into it. Of course, we're attorneys. Let's give our attorney disclaimer. This is the information as it exists today, based on the law as it exists today, July 14th, 2021. It is presented for educational purposes only. It does not constitute legal advice. So while Clint said this, or Sipra said that, it really is educational. And many of these issues will depend on how your governing documents are written and interact with the laws we're going to be chatting about today. If you need legal advice, be sure to consult with your attorney. So Sipra and I are going to have kind of a conversational discussion as it relates to management certificates and then all the multiple types of 209 hearings today. It really is, this is kind of a practical approach. We want to try to guide community associations as much as we can. And for these two areas, it really does apply to single family communities only. So those communities bound by Chapter 209 of the Texas Property Code. And it doesn't have that same sort of applicability to condominiums. So for those of you that manage condominiums, be sure to carve those out of your head because this presentation today really does not discuss that. Ms. Boyd, anything else to add for our disclaimer before we dig in?
I think you got them all.
Perfect. Thank you. All right. New management company definition. Management company is defined under 209.002 to be a person or entity established or contracted to provide management or administrative services on behalf of property owners associations. So that is what our management company is now. And again, applies to single family. Let's get right into management certificates. Guess what? They have got to be filed with the Texas Real Estate Commission, TREC. TREC, of course, doesn't have a system for filing management certificates right now, but they've been tasked with coming up with a system for filing. So in the coming months, we will probably see more information from TREC on how to do it. Here's kind of a summary and some issues to consider, but I'm going to be taking a deeper dive into this on management certificates, and let's go ahead and dive right in. Okay, so first and foremost, Section 10 under Senate Bill 1588, again, single family only, not condominiums, amends A, B, C, and E of the 209.004 and then adds a new subsection B1. So let's go line by line here. Here is our new A. A property owners association shall record in each county in which any portion of the subdivision is located a management certificate signed and acknowledged by an officer of the association, so president, vice president, secretary, treasurer, or there's an or, it's either or the managing agent of the association. And this management certificate has to include this information. So the name of the subdivision, that's been around. The name of the association, again, no change there. The recording data for the subdivision, no change there. That basically means the plat information. So the plats, the recording data for the declaration. Now here is the change. The recording data for the declaration and any amendments to the declaration. So not only do we have to have the information for the original declaration, we now have to include information as it relates to any amendment to the declaration. What does that mean? So there are so many supplementary documents to our declaration that we have to look at. Let's kind of focus on a master plan community. This may not be as applicable to some of the smaller communities, but we'll use the master as a good example in our discussion here. We've got our master declaration. It's our big declaration. It applies to all capital P property in the master plan community. Now, under that master declaration, you may see what are called development area declarations, or DADs. You may see something else called supplemental declarations. Those two types of documents, if they add restrictive covenants governing the capital P property, they are considered a declaration that must be included in the laundry list. So that's kind of core principle number one. Number two, what happens if we amend a declaration or amend a development area declaration or somehow amend a supplemental declaration that adds restrictions? Those amendments must also be included in the management certificate listing. What if there is merely an annexation document or merely a notice of applicability? So an annexation document and notice of applicability are fairly similar in scope. What they do is they add property to the association and subject it to the declaration and the enforcement powers of the association. It basically says, hey, this dirt over here, we're going to pull it in and make it subject to our governing documents, to our master declaration. Those, under a reading of this requirement, I don't think technically we have to include them unless, here's the caveat, unless those documents add deed restrictions specific to that parcel. If there are new restrictions added to that specific parcel, they must be included as an amendment to the declaration. Why? Because declaration is a defined term and it basically indicates there are restrictions applicable to the capital P property. So, Sipra, do you have anything to add on this particular issue? It's a difficult one.
The only thing I would add is the fact that there might be either an annexation document or a notice of applicability means that there's going to be additional subdivision, whether it's a section or by meets and bounds, that's going to need to be, the recording data for which is going to need to be added to the management certificate. So by virtue of adding additional land, you're also going to probably more than likely need to add or amend your management certificate. So it might be just beneficial to dump the information for the annexation in there. It's kind of a case by case probably analysis on whether it should be or not, but it's kind of 6 1/2 dozen. So just another consideration while you're having to amend all your management certificates.
And again, for this first hit, remember this becomes active September 1st of 2021. So in a mere 6 weeks, it is going to be applicable to every single family community in the state of Texas. What do you do, at least for this first round? And, we recommend all management certificates be prepared by your legal counsel. But at least for this first round, rely on the advice of the association's legal counsel. Have him, her, or they prepare the proper management certificate documentation to make sure you get it right. And I'll explain in a minute why it is so important that you get it right. Because if you get it wrong, there are going to be some pretty big teeth or ramifications. All right, so that's number 4. Number 5, the name and mailing address of the association. Nothing new there. Again, have your name, have your mailing address. The mailing address is typically the management company for those of you that are managed by a professional company. If you are not, I don't recommend using a homeowner's home address. Use one of your, hopefully you're utilizing somebody to help you unless you're a very small community. But if you've got questions on the best mailing address to utilize, again, work with your counsel if you do not have a manager. Number 6, the name and the mailing address, telephone number, new, and email address of the person managing the association or the association's designated representative. So again, name, mailing address, telephone number, email for your managing agent if you've got one. If you do not have a managing agent, i.e. management company, you're going to have to designate a representative, whether that's an officer on the board or somebody who helps you with your bookkeeping on the back end and is willing to be your designated representative for the purpose of resale certificates. So, this kind of goes back to why is a management certificate filed? One of the big reasons for filing management certificates is so that the title company knows who to contact for getting a resale certificate for that community and assist in closing of that property. All right, so that's number 6. Number 7, this is another tricky one. The website address of any internet website on which the association's dedicatory instruments are available in accordance with section 207.006 of the Texas Property Code. 207.006 was likewise amended this legislative session, and it basically requires you to have a website. If you meet, I think it's 40. Does that sound right, Sipra? Is it 40? More than 40 lots?
I think that's right.
Yeah. I believe if it's more than 40 lots, you have to now have a website that has all the dedicatory instruments available. Doesn't say the public was removed, but it does say available to basically owners in the community. So can you have a login and password so that only people who have that login and password can access the dedicatory instruments? I think legally, interpreting 207.006 and then this new management certificate requirement, I think legally you can make that argument. But from a practical standpoint, does that make sense? You've got to look at who is requesting this management certificate, or who is looking at it, excuse me. It's title companies and potential purchasers. Do they have a login and password? No, of course not. So why would that information need to be on the management certificate if they can't access the documents? So should you have it publicly accessible? I think there's a good argument that you should, but from a legal perspective, I think we can make an argument that you do not have to have it from a legal perspective. Now, should you work towards it over time? That's probably sound advice. Again, get with your counsel to see what he or she or they say. But for the time being, y'all may not have time or the ability to create this website that's open to the public with all these governing documents for all of your clients. I'm speaking to managers and management companies right now. So it may not even be practical to have it publicly available. And again, the law is written such that we can make a very good argument that that is not required. Okay. Number 8, the amount and description of a fee or fees charged by the association relating to a property transfer. Fee or fees charged by the association relating to a property transfer. What are those? Well, I think we're taking the position that that includes everything, all the fees relating to the conveyance of the property from owner 1 to owner 2, from seller to buyer. If it is a fee and defined as a fee and it activates when there is a conveyance, then it should be included on your management certificate. Now, we've got some management companies argue that, well, if it's the management company charging the fee and not the association charging the fee, then we technically do not need to include it in our fee schedule for the management certificate. Again, I'm not going to dive into that argument, but I will say this: get with your association's legal counsel to get a formal opinion on that. And ultimately, it's up to the management company to decide how they're going to be disclosing those types of fees. Sipra, this is another odd one, number 8. Do you have anything to add on that particular issue?
No, I mean, again, we're not going to dig too deep here, but this arguably includes foundation fees or cap fees, any fee that springs or becomes due as a result of the transfer. So again, takes a little bit of a deeper dive with your attorney to make sure that all those fees are covered, because as Clint's going to explain, there is a big ramification if they're not. And then I also wanted to chime in that this actually applies to lots or having a website. It's any associations that have 60 lots or more, not 40. The 40 lot limitation deals with the ACC members that cannot now also be on the board. So different statute.
Thank you, Sipra. 60, not 40. Now, I've got some questions on this before we move to the next slide. First one, if there is an amendment after the management certificate is filed, does the certificate need to be refiled? What do you think, Ms. Boyd?
Yes, ma'am. Yes, sir. That any changes to the management certificate, which would mean a new amendment and any new supplement, or like Clint said, anything that adds a restriction, will need to be updated within 30 days of the change. So anytime there's a new document that falls within this category, or a change to the management certificate, if there's a new email, if there's a new transfer fee, if there's anything that's impacted by this, then you're going to need to file a new management certificate within 30 days after that change.
Absolutely. Next question, please define declaration. Does that include bylaws, incorporation, along with amendments? ? So good news is declaration is defined in 209.0023 of the Texas Property Code, and it means an instrument filed in the real property records of a county that includes restrictive covenants governing a residential subdivision. So again, if there are any deed restrictions, any restrictive covenants binding the capital P property in one of your documents, then it is defined as a declaration and must be included in the management certificate.
I think just to point out kind of a distinction, because people may be being confused with the term dedicatory instrument or governing document. Those terms are also defined in 209, and they mean the broader realm of documents that govern an association. So the term dedicatory instrument would include bylaws, possibly articles, rules, and policies. Here we're just talking about your master covenant document, not those additional documents.
Absolutely. Next question, will we need to re-record management certificates for all associations? If so, by when? When is the magic date, Ms. Boyd?
September 1st is the magic date for re-recording all management certificates, and arguably everyone needs to record a new one, because I doubt that your management certificates have the additional information that this statute requires, an email, a website, the transfer fees. So arguably everyone's going to need to record a new one. The TREC filings don't have to occur until, I think, December 1st, with an ultimate deadline of June of 2022, because TREC needs to get their systems in place to accept these filings. But as far as everyone on the webinar is concerned, September 1st is your deadline. That's we think is of utmost importance.
So to be clear, to update your management certificate, which, as Sipra mentioned, applies to 100% of single-family communities, high likelihood, September 1st. You've got to file it in the county records. Now, if you already have a management certificate filed, then you have until June of next year to file said management certificate with TREC. So that's the TREC filing deadline. That is not the county filing deadline. County filing deadline is September 1, 2021. So keep that in mind. And then next question, does the management certificate have to be refiled each time there's turnover in the community manager? If it is the same management company, I would say the answer is no. And I would recommend using a general or broad form email address for the management company so that all requests go to one email, so that you don't have to worry about this individual manager turnover and having to update your management certificate each time there is a turnover. Now, if you go from management company 1 to management company 2, yes, you do need to update your management certificate, and you've got 30 days to get it done. So if there is an amendment to the declaration, if there is a change in management companies, you've got 30 days to get your management certificate updated. Next question, can we not use a general company email address? Very good question. And yes, I absolutely recommend that, so that you don't have to worry about the changes to the management certificate when a manager changes for managing a particular association. What if the HOA does not have a website? I think we now have to get one if you meet that 60 requirement. So if you're above the 60 lots, you have to get one.
I think there's some confusion on that one, Clint. Some people are saying that it's only if you have a management company do you need a website, and that's not true. It's any association with 60 or more lots, or as an association that's managed by a management company. It's everyone.
Yep. So if you're a 30 lot community and you're managed by a management company, do you have to comply?
Ooh, that's a good question. I think so.
Yeah. Agreed. Let's see. Anything else before we move on? No, I think we've. Oh, instead of a website, can it instead be an owner portal? I think a portal is a website, right? So it's got the HTTPS : That's good. That constitutes a website, in my opinion. Sipra, you agree?
I agree. I think, I think that's the conservative approach to making it available. Again, the publicly accessible was removed. So if it's somewhere out there in the interwebs, I think you're complying.
This does not include policies. As Sipra mentioned, there can be some confusion between the definition of declaration and the definition of dedicatory instrument. So keep that in mind. And again, if you're unsure whether or not something needs to be listed, get with your counsel. He, she, or they should be able to help. All right, let's move on to the next slide. Okay, here is that 30-day requirement that we just mentioned. So if there is any change in one of the items described in the new management certificate, you've got 30 days to update that management certificate with the new information. Anything else? TREC, we've already discussed. So again, we've got that June deadline as long as you've got a management certificate on file to file with TREC. We have a September 1st deadline to file with the county where the property is located, county or counties. Sometimes the property, lays over 2 counties. And in that instance, you need to file a management certificate in both counties. All right. Next slide. Okay. Here's some liability. We are not liable. The association and its officers, directors, employees, and agents, which in my opinion would include a management company, are not subject to liability to any person for a delay in recording or failure to record a management certificate with the county or with TREC, unless the delay or failure is willful or caused by gross negligence. So that's a standard of care. It's a pretty high bar. most companies or associations won't fit within that exception. Okay, here we go. We don't file one, or we don't file it right. We miss certain information that is required to be filed. Number one, this is old. The owner, the bona fide purchaser, is only responsible for paying amounts due and owing after the effective date of sale. So we have a bad management certificate, a sale goes through, and Bob purchases on that particular lot. There's $5,000 in past due assessments. Bob doesn't have to pay that past due amount. Why? Because we didn't comply with the management certificate requirements. Now, here is a big one, a big addition. An owner is not liable for attorney's fees incurred by an association relating to collection of delinquent assessment against the owner, or interest on the amount of a delinquent assessment. If the attorney's fees are incurred by the association, or the interest accrues during a period the management certificate properly created management certificate is not recorded with a county clerk or electronically filed with TREC. So again, it is so important that we get it right, because if we get it wrong, we don't get any attorney's fees for collecting delinquent assessments, and we don't get any interest for collecting delinquent assessments. That is a very big fee, and those fees have to, or the attorney's fees have to stay on the account or actually remain due and owing. So it's something the association is going to have to pay if this management certificate is not done the right way. So they added some pretty big teeth for failing to properly file. Ms. Boyd, do you have anything to add on this one before I get over into Q&A?
No, I think you hit the nail on the head. You know, this is just a very serious ramification on top of some other ramifications that we're not going to talk about today. But the legislature really came down on associations to make sure they're doing what they're supposed to statutorily. So really, really encourage you all to work with your attorneys to make sure you're in compliance, because you don't want to lose the ability to recover attorney's fees or interest. I mean, you're just shooting yourself in the foot if you don't do that. So just, again, couldn't say this with I guess more concern, but make sure you're working with your attorneys on these.
Yep, absolutely. All right, let's get into questions. Is the authorized agent of a community association appropriate to list as a designated agent? Yeah, that's fine. Do we need to provide resale certificate fees on the management certificates? These are not required for every transfer. They are only provided when requested. So fees related to the conveyance of a property. So if we can go back a couple slides, let's go back to number 9. Look at the wording. One more, 8. Okay. The amount and description of a fee or fees charged by the association relating to a property transfer in the subdivision. I recommend a resale certificate fee be included. I understand resale certificates are not mandatory, but discretionary or optional. But I still think you should include that as one of the fees. Sipra, what do you think?
I'm going to agree 100%. I've got some, background information about where this provision or this statute came from, and realtors are really frustrated, really frustrated enough to obviously lodge this campaign. But apparently when, a homeowner goes to closing and there's a ton of additional either transfer fees or resale certificate fees, whatever the fees are that we're charging to get them all of this information that we're now being required to provide them, they're getting frustrated. So I think in the spirit of being transparent, even if it's optional, the resale certificate request, it's probably just a best practice to put that fee on your management certificate, because it gives them the information they need to know how much they're going to potentially be out of pocket upon that conveyance.
So Sipra is kind of referring to legislative history on this one, and she's absolutely right. So these realtors and buyers and title companies were getting frustrated because all of a sudden all these fees pop up and they didn't know about them, right? They had no clue about them. So they're looking for that transparency. That's why it's important to yes, include them as one of your fees. Next question. Management companies are filing changes to restrictions with a management certificate. Uh-oh. First and foremost, that is a big no-no. If you are a management company out there listening or a manager, make sure you never, ever file a dedicatory instrument attached to a management certificate. It gets misfiled by the county clerk. It gets missed by title company researchers because it's not supposed to be there. A management certificate is supposed to be a 2 to 3 page document listing the items required to be statutorily listed. It is not a notice provision or notice document to attach a declaration to. So please, please, please stop doing that. It can have some pretty big legal consequences down the road in terms of chain of title and attachment of the restrictions to the capital P property. I think Sipra and I could spend a couple hours talking about that and all the case law, but just don't do it. And if you have done it, get with your attorney and management company ASAP to get it fixed, because there are some problems associated with that. Okay, just to confirm, communities with at least 60, not 40. Yes, that is correct. Sipra looked it up. 60 is the magic number. ACC and board, Ms. Boyd is going to be discussing the 209 hearing requirements and the 40 lot requirement as well here in a minute. Public accessibility website. Governing documents are already filed with Harris County and is available to all. So that is county specific. Some counties, yes, they are available to the public and you can search it and get a copy of it, an unofficial copy. Other counties, that is not an option at all. So that's where this management certificate requirement kind of comes into play. It allows buyers and title companies to more easily obtain the documents governing the community. Could this overdue fee fine due the HOA from, I'm not sure I understand that question. Are we able to list the management company's website address on the management certificate if anyone can access the association's page from it? Yeah, I think that makes sense. As long as it's a sensible approach, you log into the website and there's something on there, you need a resale certificate, click here, or something along those lines so that it's very easy to get the information you need.
The next
yeah, again, these are all specific questions. Get with your counsel. Go ahead, Sipra.
I was just going to say the next few questions are all pretty much the same. I think if the association is managed by a management company that has that service available to them, where they'll place all of their documents on the management company's website or the website associated with the association, then I think it complies.
Now, the penalty that Sipra and I were talking about on not having a properly filed management certificate, is it forever? No, it's just for the period that you don't have a good one on file. The minute you get a good one on file, that penalty kind of dissolves so that you're good to go moving forward. And with that, yeah, I think to Sipra's point, all these are more kind of specific that we're not going to get into. I'll turn it over to Ms. Boyd to discuss our 209 hearings.
All right. Okay. Great. Thank you. All right. So I'm going to spend the last half of our presentation on Senate Bill 1588, Section 11 and Section 18. Those two amendments specifically dealt with what I'm going to use the term 209 hearings. So these are hearings that now are, well, some of them were arguably, I guess, required under 209 already, but the new legislation added some changes to how those hearings work, and they kind of split the baby with how these hearings work, because under one provision, the hearings work the old way, and under another provision, the hearings have a new aspect to them. So let's dive in. Section 11, the amendment to Senate Bill 1588, deals with the Architectural Control Committee or the Architectural Review Committee, whatever it's called. I've seen it called Modifications Committee, New Improvement Committee, whatever it is, the entity that reviews any architectural control applications. This is what it's referring to. And essentially, Section 11 now says, or the change to 209 says that and a person that serves on the ACC cannot also at the same time concurrently serve as a current board member, a current board member's spouse, or a person residing in the current board member's household. So anybody cohabitating with the board member. So for all of you that have probably a lack of interest from volunteers, and so your board members are also functioning as your architectural control committee, you have to stop. And while this is only this is effective September 1, we're encouraging everybody to go ahead and do it immediately so you can start the process of trying to find volunteers. And this was one of the unintended consequences that we were talking to the legislature about. This is going to be a problem. We're not going to have people to fill these roles. But here we are. We've got the statute, and we've got to deal with it. So I'm going to kind of leave that there. Work with your legal counsel to talk about any specific questions you might have about that issue, because I'm going to dive in deeper to the 209 hearings.
Does that apply to developer-controlled communities?
It does not apply to developer-controlled communities, and the limit. I think this was a question that we kind of confused early on. This particular provision applies only to homes that have more than 40 lots, 40 or more lots. So the management certificate is 60 or more lots. The ACC, I guess, restrictions apply to associations with 40 or more lots, and there is a developer control exemption. The statute also says that an owner is now permitted to appeal a decision by the Architectural Control Committee to the board. So for those of you who have autonomous ACCs that are elected and not appointed by the board, arguably, and I think this is a best practice, and Clint, feel free to chime in, but we think that this applies to autonomous ACCs as well.
Absolutely agree.
The other important part about this provision is that notice that you send in response to an architectural control application. And I'll remind everyone that sometimes there's some deemed approval language in your restrictions. So if you don't respond within 30 days or 60 days, that application is deemed approved. So you need to make sure you're reacting quickly and either sending out a denial letter quickly, or an approval letter quickly, or conditional approval quickly, so that the deemed approval isn't triggered. But in the notice of denial now, you have to also include the basis for the denial, and in reasonable detail explain any changes that the homeowner might need to make to the application if it's for a conditional approval. So sometimes it's approved conditionally based on XYZ. You need to, again, detail those specific changes or modifications that need to be made, so that the homeowner understands why they're either receiving the denial or the conditional approval. And then the notice also has to provide the owner a notice in that denial letter that the owner has a right to appeal, and that hearing on the appeal has to, I don't think that Clint, correct me if I'm wrong, I don't think there's a time limit on when that appeal needs to be triggered. I'm guessing that we should probably do it within, anywhere between 10 or 30 days. But if there is an appeal, then that appeal needs to happen within 30 days of the request that is made by the homeowner. Clint, any thoughts on that?
Yeah, no, I mean, that's the general rule. But what I tend to find is reach out to the owner, work with the owner. And if you say, hey, here's when the board is available, most of the time that owner is going to be fine with it. So again, work with the owner, try to get something that all parties agree to. And many times that time limit is not a concern.
Thank you. So again, this is a 209 change and applies only to single family, and it's effective September 1st. So again, get started on these changes quickly. Next slide, please. Okay, so in terms of the hearing, the notice, if a homeowner requests a hearing, the notice sent to the homeowner must provide the date, time, location of the hearing, and it has to give the homeowner 10 days notice of the hearing, and only one hearing is required. And this hearing process, I think what they did is basically they stole the language of the old 209 hearing process for covenant enforcement under section 209.006. So this hearing process, and again, I'll dig in a little bit deeper, but during the hearing, basically the owner is provided an opportunity to discuss and verify the facts and basically resolve the denial or the conditional approval by the ACC. Both the board or the owner are permitted one postponement of 10 days. And then obviously both the board and the owner can agree, I guess, collectively to extend it longer, but you want to get these out of the way. And as always has been permitted, an audio recording can be permitted by both parties. So that's the Senate Bill 1588, Section 11 changes that are related to 209 hearings for architectural control approvals. Next, I'm going to talk quickly about the other type of 209 hearings under Section 18 of Senate Bill 1588. And this specifically amends that old section that everybody's familiar with regarding the enforcement of deed restrictions, levying fines, and property damages. So what they changed on this, and what I'm hearing across the board, is it's now the 209 hearing has become kind of like a mini trial. Not later than 10 days before the hearing, the association has to deliver a packet to the homeowner, and the packet has to contain information or evidence that the association plans to introduce at the hearing. And specifically that includes photos, documents, which we think would be letters relating to the violation, and any communication. I'm getting specific questions about whether communication means, all communication between and among the board. And I think you have to use your judgment. I would try to limit the information, one, not only to what you intend to introduce, but if there's communication between board members about the violation, or especially if there's communication between the association board, the management company, and its legal counsel, then those specifically should be included from that packet. If the evidence that is required under the statute is not provided, then the owner is automatically entitled to a 15-day postponement. And then another change regarding the hearing process is that the board has to present its case first. So the association goes first, and then the owner is entitled to present his or her case after the association's case. And this is a big change because, historically what I would tell my boards is this is an opportunity for the homeowner to vent and kind of explain why they have an issue with the violation notice they received or the fine letter they got. And so you just want to give them an opportunity to talk and listen. And after they've talked and listened and asked questions, the board will then deliberate, excuse the homeowner, deliberate and make a decision and get back to the homeowner probably within, a short period of time after the hearing. Well, that's all out the window for 209 hearings now, not the ACC ones. Again, that's different. The association has to present its case first. Any thoughts on that, Clint?
Yeah, it really has caused a big mess. And look, for some of the simpler violations where an owner requests a hearing for a grass, your grass is too long or something along those lines, the evidence packet is going to be pretty easy to put together. And the quote unquote 209 hearing is going to be easy as well. Hey, Bob, here's a picture. Your grass is too long. There's our evidence. We sent you a notice saying to clean up your grass. Bob gets to present his case. Well, I don't think it's too long. Well, sorry you feel that way, Bob, and you're done. But for some of the more complicated or complex violations, of which there are many, that evidence packet's going to become more voluminous. There's going to be a more complicated case in chief for the association There's going to be these kind of questions back and forth, cross-examination. They get to put their case in chief on, and it really does become more difficult and more like a mini trial. In those instances, you're likely going to need your counsel to guide you through the process, at least the first few times, and maybe for some of the bigger issues in perpetuity, just because there's so much opportunity for you to say the wrong thing. And because these can be recorded, and an owner could then use that opportunity where you said the wrong thing or did the wrong thing, use it against you in trial if this is something that ends up in litigation. So there really is a lot of opportunity to do this wrong for the more complicated matters. So again, get with your counsel to make sure you're doing these new mini trials the right way.
I've actually had a couple of managers ask me if I would attend some of their first few, and obviously that's at the cost of the association, because we can't charge that cost back of having me attend the hearing, but they really just want to make sure they're doing it correctly. So that's an option, or at least you can have your attorney kind of in the background listening in. Again, effective September 1st, 2020, that should say 2021, that's a typo, and then applies only to single family. Okay, so I'm going to dig in again a little bit deeper because I've got lots of questions on this. We've got two different types of 209 hearings. 209 hearings for architectural control or architectural review, and that's on the denial of an application. That's one type of hearing. And then the 209 hearings under section 209.006 of the property code, which generally deals with deed restriction enforcement, suspension of privileges. What we're suggesting or recommending is adopting a policy specifically related to the different types of 209 hearings, and modifying your existing policies. A lot of you, if you guys work with us, we've recommended and probably have drafted collection policies, deed restriction enforcement and finding policies. And within those, there might be a section that deals with 209 hearings and the proper procedure for those. So either or, but pick one. I think that having a policy recorded will help boards and your management companies understand kind of the detailed process that they now need to use for these 209 hearings. So I'm going to spend the rest of kind of our 10 minutes left again digging in a little bit deeper on the actual hearing process, and hopefully this will answer some of the questions that I'm seeing that are coming in. This is just on I'm going to talk about each type of hearing. So just on the ACC ARC application denial, the notice requirements, again, to reiterate, you have to explain the basis for the denial in reasonable detail or the basis for the conditional approval. After the denial, in that notice, the owner has a right to request a hearing within 30 days of that denial, and that they also need to be told that if the denial hearing is front of an ACC or the ARC, that decision can be appealed to the board of directors. So that needs to be part of your letter process. Again, at the hearing, this is the old version of the hearings because they again just adopted that language that used to be in 209. Discuss and verify facts and attempt to resolve the denial or the conditional approval. One postponement, either party may record. And then really one thing that I think is important and I think has gotten lost is remember those 15 items under the 209.0051 that have to be voted on or approved by the board in an open session in a board meeting. Well, the hearing on the denial of an application, an ARC application, has to be conducted in that open session. So make sure now you're having to deal with these, assuming they're going to be happening more often because you have all these notice requirements that are put into play on those ACC notices. Then those hearings specifically have to be in the open session. And again, the owner has a right to appeal that decision to the board.
Well, and I guess Sipra on that one, it's just so difficult sometimes to do that 209 hearing in open. And I'm looking at 209.051H right now, and it says the board cannot consider or vote on appeals from a denial. So would you consider a hearing considering an appeal? Or could you have the 209 hearing in executive and then consider that hearing and that appeal during open?
That's a good question, Clint. And I don't, again, I think the conservative and maybe best practice approach might be to go ahead and have the hearing in the open. Again, very conservative, because I know that's just going to, elongate your hearings. But no one knows what the definition of consider is in 209. It's used throughout 209. So whether consider means the actual hearing or after the hearing's over, when the board is deliberating, no one knows. I don't know. What are your thoughts on that conservative approach?
Yeah, I think you've got to make a decision one way or the other for 209 hearings, but I really think an association could do the 209 hearings during executive session, because it really piggybacks on the right for an owner to keep deed restriction violation histories private. So there's that privacy concern. If we're dealing with a potential violation here as it relates to the improvement, I feel like an association could make a good argument that the 209 hearing, the facts, the circumstances, all the nitty gritty can stay private. But again, considering and voting on the actual appeal, you would do during open, but you would just try to maintain that privacy that you've established in the executive session. That's kind of my 2 cents. And then number one, and then number two, there's another section in 209.051 that basically says you can consider things during executive session that are agreed to remain private by the parties. Let's see. Matters that are to remain confidential by request of the affected parties and agreement of the board. So when you're scheduling that hearing, if you can include in there, this hearing will be conducted during executive session to maintain confidentiality. Please confirm the date, and please confirm you're available for that date and that you're okay with it remaining confidential. You kind of include that in there. You've got an even better argument to keep the 209 during exec.
Good point. I like it. So
yes.
Another reason why everyone on this webinar needs to work with their attorneys, because there's lots of interpretations out there and possible ways to go about complying with the statute. So to wrap up kind of the rest of my portion, and then we might have a few minutes to field some questions. Again, just hitting real quickly on the hearings that now have to be conducted under section 209.006 of the property code. And those, just as a reminder, are the hearings that have to be provided, or at least an owner has to be notified that they're entitled to one, on those curable and uncurable violations when they get a notice for that. If the homeowner is going to be their privileges for either common area usage or some common area rights are going to be suspended, and that can be in connection with either a deed restriction violation or the failure to pay an assessment. Any notice to a homeowner regarding a property damage amount that the association might be seeking. Sometimes that deals with, if a homeowner, runs into a gate when they're coming into the subdivision, or some other damage to the common area. And then obviously fines. Before you can levy a fine, you have to send the 209 letter and give them an opportunity to request a hearing on that fine. And just a reminder on these, the hearing packet has to be delivered 10 days before the hearing. I think I saw a question maybe from Bill about, if you get the packet to them sooner, can you have the hearing sooner? That's a good question. I don't know if the 10-day limit is there just to give the homeowner time to get their information and documents together, but it does say that they have to have at least 10 days notice of the hearing. So to me, that I think that you can't have it sooner technically, but I don't see anyone complaining if you reach out to the homeowner and say, hey, look, let's do this in 5 days. As long as you agree, maybe get it in an email, then I don't think anyone's gonna complain about that. remember to put all of those documents. If you have a specific question about a photograph or a communication, reach out to your legal counsel about whether or not it should be included in that packet. And again, a lot of wasted time if you don't get that packet to them. It's an automatic postponement of 15 days if it's not delivered. Specifically for the association has to be prepared to present its case. The owner then presents his or her case. Either party can record the hearing, and then obviously the association must notify the owner that they have a right to appeal a decision to the board if the hearing is in front of a committee. That's that one section where if your hearings on under 209.006 are conducted in front of a committee instead of the board, then I don't think most people do that, but just know that if it's done in front of the hearings conducted in front of the committee, then they have a right to appeal that decision to the board. And then just to wrap up, and again, I know there's a bunch of questions that are coming in, and maybe Clint, you can start looking at those while I'm finishing.
Yep.
But in terms of 209 hearings, I want to be clear, there's now two different types of 209 hearings. One that's related to architectural control, and then now one that has always been around but has been modified to require, a mini trial essentially on the deed restriction enforcement and fining process. So make sure you're either adopting new policies if you don't have any, or modifying existing policies. Understand that there are subtle differences. I don't think there's a reason to do the same amount of work for those architectural control hearings as there is now for those 209.006 hearings, because it's not required under the law. So I would try to keep those as simple as possible and not mix the two. Obviously, this is going to require all associations and management companies, boards, even attorneys to really be prepared in preparation for those 209 hearings and to respond timely so that there's not automatic delays. All right, so what kind of questions are we looking at, Clint?
We're all over the place. And Sipra, just a comment, there's actually 3 types of 209 hearings now, right? The credit bureau as well, which we didn't discuss today because we're not talking collections. It's really deed restriction enforcement and architectural restrictions. But keep that in mind. There's a new hearing for those of you that report to credit bureaus, and there's a bunch more hoops you've got to jump through before doing a proper reporting. Regardless, as Sipra mentioned, it's imperative that you update your management certificates. It's more complicated now, so get with your counsel to assist you in that, number one. And then number 2, adopt those policies so that you're doing it the right way and not violating these new 209 requirements. With that, let's get down into it. Can the packet be provided electronically, Ms. Boyd, for the 209 hearing?
I think so. I don't think there's any specific prohibition or specific indication about how the packet must be provided.
Now, if the owner doesn't communicate with you via email, only through paper, and you don't have an email address, obviously you're going to have to paper snail mail it. We've already answered that one. Oh, can the head of the ACC be a board member, Sipra?
Nope, I don't think any ACC members can be board members. Now, we've had questions, and I'm seeing some roll through about, can a board member serve in some type of supervisory capacity? And I think that's okay as long as that board member is not injecting their opinion into the decision or involved in the decision. I think that there is a desire, as established by the statute, and a strong intent for these two entities to be completely different so that the same 3 or 5 people don't have control of the board as well as the ACC. So try to make them as separate as possible. Some of the other questions we're getting are about whether or not a management company can serve as the ACC. We are suggesting, and this is really document intensive, you've got to review your restrictions with your attorneys to make sure that that function of the ACC can be delegated to a third party. And if it can, and it's expressly provided for, then potentially the management company can serve as the ACC, or you can hire an outside, third-party ACC company. There's some architectural design firms. Now, those costs for those are obviously going to, increase because they charge a pretty penny to review architectural control applications. But that's also another option, with the caveat that you have that authority to delegate that function to an independent third party.
And we've run out of time on a lot of these questions. We'll do our best to respond, but keep in mind that, look, this is not the only webinar we're going to have on 209 hearings, and we may even have one on management certificates as well. But our firm just saw these two issues as big ones. There are a multitude of big issues with the new law, but management certificates and these 209 hearings, September 1 is only 6 weeks away. And we want to make sure all of the associations, whether we represent you or not, are well prepared. So we decided as a firm to have this one out there, but know that there will be more in the coming months, number one. Number two, hopefully y'all have got counsel so that you can rely on him, her, or they to really assist you in navigating these issues, because they are issues and they're big ones. So hopefully you can lean on them to help guide you through the next process. But hopefully what Sipra and I provided today gave y'all some benefit. As shown on this, we've got a couple more webinars coming up. Don't sign that proposal relating to contract interpretation presented by one of our shareholders, Brady, out of San Antonio. And then we've got the old nuisance animal problem on July 27th. And that is going to be presented by one of our shareholders, Cliff, out of Houston. With that, that's it. I've got to say goodbye, Sipra.
Goodbye, Sipra.
Y'all enjoy the rest of y'all's day.
Thanks, everyone. Have a great week.